Welcome to Employment Law This Week. I'm George Whipple. The Federal Trade Commission announced its final non-compete rule on April 23, 2024. The legal challenges began immediately, first from the company Ryan LLC and the U.S. Chamber of Commerce in Texas, followed by additional lawsuits in Pennsylvania and Florida. And then came the Supreme Court's Loper-Bright decision overruling the Chevron doctrine. Less than a week later, the Texas District Court enjoined the FTC's non-compete ban with a plan to issue a final ruling by August 30th. While the FTC did not rely heavily on Chevron in its Texas briefing, the High Court's decision will impact this case. We turn to Epstein Becker Green's Spilling Secrets podcast panel for context around this rapidly evolving story. Erik Weibust filed one of the amicus briefs in the Texas litigation, challenging the FTC ban. In the podcast recorded on July 15th, he gave us some details about that ruling.
The court declined to issue nationwide injunctive relief or even to find associational standing. Associational standing means that the U.S. Chamber and the other industry organizations have standing on behalf of their members as opposed to just the organizations themselves.
As a result, the injunction applies only to the named plaintiffs, not to any of their members or other companies. But Erik thinks it's likely that the court will ultimately find associational standing at a minimum. The final decision is scheduled only 2 business days before the FTC's non-compete ban is set to go into effect on September 4th. Spilling Secrets host and member of the firm, Pete Steinmeyer, discussed how employers should prepare.
In the short term, I'm not advising any changes in the face of the proposed non-compete ban, but I am telling my clients to take the long-term view and to use a holistic approach towards protecting your workforce, your trade secrets, and your customer relationships. And traditional non-competes are just one tool. There are many other tools, such as confidentiality agreements, trade secret audits, garden leave clauses, customer non-solicits.
Epstein Becker Green's Paul DeCamp gave us some context as to where the FTC's ban will fit into the evolving understanding of federal agency authority post-Chevron.
I think that there are multiple hurdles that the rule will face in court, even if it were to get past the Chevron/Loper-Bright type threshold issues of authority to issue the rule. I think at the end of the day, lurking beneath all of this is the underlying question of, even if Congress did give the FTC this authority, can it give the FTC this much authority, which raises a non-delegation issue, which is really the next frontier for the Supreme Court as it expands its protections of the boundaries between Article 1 and Article 2 of the Constitution.
Thanks to Paul, Pete, and Erik. And thank you very much for watching. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much, and we'll see you next time.